Hello and welcome back. I'm Steve Murphy, a trust and estates attorney with McGuire Woods LLP, and this is Legacy Planning Once Removed, my podcast on estate planning, trusts, property, taxes, family legacy, and everything else on my mind. This episode is about a concept called a trust letter of wishes. It's all about how to express those wishes and your goals for how the trust will operate in the future. But as we'll see, one question is going to be, what should we even call this thing? Should it really be called a trust letter of wishes, or should it be called something else? We'll get to that. So just as a reminder, we talk a lot on this podcast about three aspects of a trust. I call it access, control, and flexibility. Access, who are the beneficiaries? Who can get distributions from the trust? Control, who's the trustee or other key decision makers for the trust? And third, flexibility. How do we build in flexibility to maybe change those terms over time? And I've talked about each of those concepts in other episodes. A question I often get from clients is, how will this trust actually operate in practice? Not just in general, but how will these concepts of access, control, and flexibility be applied in practice? Well, obviously, that really comes back down to those three key principles and the client's wishes. A question we often get from clients is how this will operate in practice. This often comes back to the guiding principles of the trust. Think back to that episode on this podcast on trustee discretion and the concept of rules versus standards. Maybe it comes down to how specific you want to be, how rule-like you'd like the trust to operate, versus how much discretion to give to the trustee or other actors. That is, how much you'd like it to operate like a standard. But as a reminder, the best person to decide all these questions is you, is the settlor, the client, the donor. So the question is, how can we find ways for you to provide that kind of guidance, to build that guidance into the estate plan to make sure it'll operate the way that you would hope? So when some situation arises in the future, the trustee will have something to draw on, some resources, maybe to answer that specific question that's come up, or maybe just some general guiding principles that'll help the trustee come up with the right answer that's most in line with what the settlor intended. Some clients prefer to address this informally, maybe with just some conversations to their future trustee. But I would have one cautionary note about treating this informally. In this podcast, we're assuming a scenario where the settlor is removed, where the settlor has passed away or the settlor has made a gift and they can no longer practically or legally control the assets. But let's take that a step further. What if the trustee is removed? What if the beneficiaries have changed? What if this trust has lasted long enough so the settlor, the advisors, the trustees, maybe even the beneficiaries that were initially in place are all deceased? In those situations, we can't just rely on the conversations these people have had with the settlor. In those situations, we'd love to have some guidance from the settlor in writing or in some format that we can draw on. And let's think about the kind of scenarios that might come up. How about dealing with some of the specific situations we've talked about in this podcast? Maybe the beneficiary would like a distribution for his or her support and living expenses, or for their education. Maybe there's a question that's come up about the purchase or use of a family cottage. We talked about that in another episode. Or the use of trust funds to purchase a primary residence. Again, we've talked about that on another episode. There are any number of issues that could come up also. We'll talk in later episodes about issues like, what if a beneficiary suffers from substance abuse? How would the settlor hope that the trustee would address that very difficult situation? There also could be very specific issues just related to the trust assets or the trust administration. Maybe the settlor has very specific ideas of how to approach trust investments, or how to approach who should be selected as trustee, or how to evaluate a business opportunity, how to evaluate charities, even things like how long should the trust last, or why is flexibility given to some people and not others. So you can imagine these types of situations come up all the time where we would love to know what the settlor would have wanted to happen. And overall, sometimes it comes down to whether the settlor would like to be liberal in making distributions or investments on behalf of a beneficiary, or more conservative and restrictive in making distributions or investments on behalf of a beneficiary. So again, we're going to come back to these guiding principles of the trust. And again, the best person to decide all this is you, the settlor, the client. Or for those financial advisors and other advisors who listen to this podcast, it's your clients too who might be setting up this estate plan. And yes, once again, the challenge is we're planning for a scenario where that key decision maker is not involved. That key decision maker has been removed. So I think the settlor definitely should provide some guidance. But here's an interesting comment. That guidance really shouldn't be in the trust document itself, or at least there shouldn't be too much of that settlor guidance in the trust document itself. Well, why is that? There's really two reasons. First, there are legal reasons why that guidance from the settlor shouldn't be in the trust document itself. We carefully draft the trust document, which is legally binding, based on very specific concerns, especially based on tax laws. There's lots of legalese in these trust documents. My clients joke all the time, there's lots of legalese, even if we try to draft this in a way that's understandable to the layperson. And I joke with my students, often when there is some language that sort of looks strange or very complicated, it's there for tax reasons. But in those scenarios, in all seriousness, if the settlor tries to tinker too much with those specific terms in the trust, that might actually interfere with the tax treatment of the trust. Could even trigger estate tax or gift tax. Another reason we draft these documents very specifically is for asset protection purposes. But if the settlor or others can exercise too much control over the trust, then the creditors of a beneficiary maybe could reach it. And there's actually even recent case law on divorcing spouses trying to get control of the trust because of language in the trust document itself. We also want to be very clear about who the beneficiaries of the trust are. Some clients like the idea of trust assets finding their way to benefit charities or spouses of descendants or the like. But again, if the language includes them as actual beneficiaries, then they might have rights, enforceable rights, to get information about the trust or to interfere with the trust's administration. So for all those legal reasons, it's helpful to not tinker too much with the actual legal drafting language in the trust document itself. But I think there's practical reasons also of why this language shouldn't be in the trust agreement. I think that these expressions of wishes should be in the settlors in your own words, and you shouldn't feel bound by this legalese. So I really like the idea of a trust document with all this specific legal language, and then maybe a separate document, this letter of wishes, that's not drafted by a lawyer or not heavily edited by that lawyer, gives you the ability to express your wishes in your own words. So we're going to come back to this question, which I love to pose with my students and my clients. What are we even going to call this thing? If you look around online, there's lots of resources that talk about this concept of a trust letter of wishes or something similar. And a lot of sources call this an ethical will. Now, the problem with that term, in my opinion, is that there's no real context, no real hook or framework of what we mean by the ethical will. I think what many practitioners and resources say is that an ethical will is your opportunity to express your values or your morals. But again, it might be hard to reduce all that to just one letter. But even going a step further, when I think about the trust context, I'm not just thinking about ethics and values and morals. I'm thinking about how this will be applied in practice in the trust setting. And in our case, how should the trust or family wealth play a role in those values and ethics and morals? So I like to call it something more specific, maybe related to a trust. I often come back to the term trust letter of wishes. I don't think that's a great term. Again, it's very general. Some clients have really had fun with what they're going to call this. Some clients call it a trust constitution. That's an interesting idea. Maybe this founding document of the trust itself that will be interpreted over time. How about a trust charter? Again, really interesting concept of this charter, this foundational document. Some clients like to bring in other terms. They call it a trust covenant, trust testament, or how about something like a trust mission statement or trust value statement? What I like about playing around with what we're going to call this document is that it even helps to guide us in what we're trying to communicate. Is it a foundational document? Is it more of a mission statement? And it also reminds us of what's the overall purpose of this trust. We're going to talk about all these concepts in other episodes, and I'm looking forward to future episodes on these concepts. But how about these kinds of purposes for a trust? Maybe it's sort of like a family bank that'll help individuals with loans and with investments. Maybe it's something like a family foundation that'll help individuals with family charitable endeavors. Maybe you could think of it as a kind of family business or a kind of family office. How about a family caring bridge to help in emergencies, especially health-related emergencies? Or a family retirement fund, a family insurance policy, a family venture capital fund, a family seed fund, or some clients like to call it a family head start fund. So again, there's lots of different purposes and goals for these trusts. That's all going to play back into this question of the foundational documents. And even something like, what are we going to call this separate trust letter of wishes? Now, in these episodes, I like to leave with sort of a thought exercise for the client, for the listener. So here's one for you. Maybe just imagine this scenario where this question has come up of the use of assets. Or maybe I like to think, imagine the scenario where the funds aren't in the trust at all. Someone has just come to you as the settlor about whether to make a gift to this person or to make this investment, like maybe to purchase a home. How would you approach it? What are the rules and standards you might apply? What are the guiding principles here? Just think about that for a little while. How you answer that question might just be the foundation of this kind of letter of wishes, or this kind of guidance you provide for the trustee. Write it out, and maybe even share that with your family. Maybe even share that with your attorney and other advisors. See if there's a way to incorporate that kind of guidance into the estate plan in some way. And maybe you share that so that upon your death, that is part of the file that everyone has. Maybe it's saved right there with your other estate planning documents, and it's easily accessed. And then some clients take this in different directions. Some clients realize that as they write this out, they really want these wishes to be technically, legally binding. They don't want this just to be guidance that the trustee follows or would take into consideration. They want this to be legally binding. If that's the case, then this language probably should be incorporated into the trust document itself. But some clients realize they actually don't want to write out this letter of wishes. But I would still say this exercise has been helpful. It's just reminded the client of how important it is to choose the right trustee, to choose the right actor who will carry out those wishes. And then again, maybe communicate some wishes informally to that trustee right now. So again, as a takeaway, this trust letter of wishes, or whatever we'll call it, it's this opportunity for you to express in a non-binding way your goals and vision of how the trust will operate in the future. But it's not for everyone. But this process highlights those important decisions and how to communicate your wishes to others so they can know about them and carry them out in the future. I'm Steve Murphy, and this has been Legacy Planning Once Removed, my podcast on thoughtful estate planning. Thanks for listening.